Assalamualaikum everyone and Madam Shayu. I'm Batrisha Hanin binti Ramlan from MC247 S3E. So today I'm going to present my cyber security case law review. My case will be YB Dato Haji Husam bin Haji Musa versus Muhammad Faisal Bin Rohban Ahmad. This case is in 2015. Okay, now I'm going to briefly explain to you about the facts of the case, which is the summary of the case. The plaintiff, who was a well-known past politician, filed a defamation suit against a blogger, which is the defendant. He claimed that the blogger circulated an article titled Husam dan Tamrin Balun Balak 15 juta via a blogspot called ruangbicarafaisal.blogspot.com. But the blogger denied that he wrote the article, and he also denied that he owned the blogspot in any certain way. SP2, which is the plaintiff's witness, went to the defendant's house at night to inform about this suit, and he had taken 13 pictures of the defendant along with his house and named this under Exhibit P3A. And on the very same night, the defendant confessed to the plaintiff's witness that he was the writer of the blogspot. But during the court trial, the defendant's IT witness, which is SD2, stated that the document was downloaded and printed from a file F, which is someone else's computer, and not being downloaded straight from the internet. So what are the issues of the case? First, whether the defendant is the owner of the blogspot. Second, if so, whether the plaintiff or the defendant have solid proof to defend their stance. And third, whether the trial judge order is fair enough and according to the law. Okay, now we're moving on to the judgment of the case, which is the final decision of the court. First, the trial judge committed error in the early judgment as well as misdirection of the law, which resulted in unfair procedural and must be seen as perverse, which means that the trial judge decision will be invalid. Second, the defendant failed to rebut the presumption under Section 114A of Evidence Act 1950. Third, 50,000 ringgit to be refunded to the plaintiff. And last one, the order of High Court is set aside and must be remitted to the High Court for assessment of damages. Okay, before I move on to my analysis and critique for this case, I would like you to have a clear sight of what is Section 114A of Evidence Act 1950. So under this section, it stated that a person whose name, photograph or pseudonym appears on any publication depicting himself as the owner, host, administrator, editor or sub-editor, or who in any manner facilitates to publish or republish the publication is presumed to have published or republished the publication unless the contrary is proven. So this means that if anyone is being blamed for any publication and there are solid proof that can relate them to this publication, they will have to be responsible for the publication and will be found guilty. Okay, my first analysis and critique will be about the defendant. In my opinion, I do agree that the defendant was truly at his fault and also being manipulative with his wrongdoings, although it is obvious that the blogspot was his. The article Mohon Maaf kepada rakan-rakan blogger has a link to the blogger and his father because it was posted on the same day that the blogger visited his father at the hospital. And also the telephone number of the blogger in his profile is the same number as his younger brother, Fakrul Rohban. But thanks to Section 114A, as it is related to cybercrime, this will assist the plaintiff to actually exonerate the defendant's liability because the defendant's defense was only a mere denial that he was the owner of the blogspot. In this case, it is considered ambush as it is using the platform as a hateful means for them to express their dissatisfaction. Next, my second analysis and critique will be about the trial judge. In my opinion, I personally think that the trial judge had taken his duty as judge for granted. He denied the law that actually should be implied for this case. Although he already had accepted the evidence as relevant and also admitted it, but he refused to consider the evidence just because his dissatisfaction on admissibility procedural of the plaintiff. It is absurd that the trial judge actually accepted the defendant's mere and bare denial defense instead of all the solid proofs that has been provided by the plaintiff. Alright, that's all for my case law review on cybersecurity. Thank you for watching my presentation. Assalamualaikum.